this Thursday, April the 19th, 2018 meeting of the Alarm Systems Contractors Board. First of all, we want to welcome our new board member, Mr. Cockburn. The other, Mr. Richard, is not with us today, but will be at the next meeting. With that being said, Ms. Vest, will you please call the roll?
Glenn Cockburn. Here. Scott Cockcroft.
Here.
Keith Harvey.
Here.
Vivian Hickson.
Here.
Lou Richard. Let the record show that Lou Richard is not present, Madam Chair, but we do have a quorum. But we would also like to thank our previous board members, Karen Jones and Ken Roberts, for their service. Thank you.
Okay, have the members had an opportunity to review the agenda for today's meeting, and if so, a motion to adopt?
Make a motion to adopt the agenda as presented for today.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Cockcroft to adopt the agenda as presented. All in favor, voice by saying aye.
Aye.
All opposed? The agenda is adopted. Next is the minutes from the February 22nd, 2018 board member. Have the members had an opportunity to review those minutes, and if so, a motion to approve?
Make a motion to approve the minutes as presented.
Okay, Mr. Cockcroft, please make sure, Cockburn, I'm sorry, excuse me. I'm going to have some
confusing, huh?
It's going to get me. You know how I am.
We may have to resort just to
say
Glenn and
Glenn
Scott.
Scott. Would that be okay?
That's fine.
Okay. Make sure that you are
Second.
in red. Yeah, thank you, sir.
Okay. We have a motion by Scott and a second by Glenn to approve the minutes as presented. All in favor, voice by saying aye.
Aye.
All opposed? The minutes are approved. Mr. Huffman.
Good morning. Now going to read the legal report. Number 1, case number 2017-071-671. Complainant noticed respondent's vehicle and worker installing CCTV. Complainant alleged that respondent was in joint venture with another company providing repair services without a license. Respondent was purchased by a new owner and a new license was issued under the new EIN without CCTV designation. The former owner was to stay on as registered agent. The registered agent had CCTV certification. The new license issued did not have the CCTV certification as it was already in place with the former owner/registered. The former owner requested to retire his license for 2 years, including the CCTV, without knowledge of the new owner. This license will retire on January 31st, 2019. Respondent was notified of this issue when the complaint was filed. The respondent has ceased all CCTV work and is in the process of obtaining the CCTV certification. Recommendation is to send a letter of warning.
Make a motion to concur with council.
I second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Cockburn to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 2, case number 2018-000421. Complainant requested cancellation of the contract and alleges respondent refused because the complainant signed a 4-year contract. Complainant alleges the signature on the contract is not of his own. Respondent alleges that complainant made an electronic signature consenting to the contract on September 7, 2016 for a 4-year term. Respondent further alleges that the complainant completed a pre-installation telephonic survey confirming he understood the terms and conditions of the contract. Respondent has offered to reduce complainant's monthly fee by 40%, which will reduce the payoff balance. There has been no response from complainant. The recommendation is this is a contract dispute and to close.
We had similar complaints against this respondent before.
Yes. This is a bigger company.
But of this same nature, we've had similar complaints. Not just complaints, but similar complaints about the signatures.
I don't believe we've had any complaints about the electronic signatures.
Make a motion that we concur with council's recommendation, but also advise both parties that this is more of a civil matter than a board matter.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Cockcroft to concur with our council's recommendation with the note that this is more of a civil matter than a board matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
3, case number 2018-005511. Complainant is the former employee alleging that respondent is operating without a qualifying agent since June of 2017 in the Chattanooga area and continues to contract. Respondent states that the former employee was hired to start the branch office in Chattanooga and therefore was a qualifying agent. Respondent has an office in Nashville and sent technicians to finish the minimal amount of work it had in Chattanooga. Respondent did not give required notice to the board. Respondent continues to look for a technician to start the Chattanooga office as a qualifying agent. Per Tennessee Code annotated 62-32-304, paragraph C, in the event that a QA ceases to perform their duties, the business entity shall inform the board within 10 working days. This business must obtain a substitute QA within 30 days unless the board, in its discretion, extends the period of good cause for a period not to exceed 3 months. As of February 20th, 2018, the respondent has appointed a QA. The recommendation is to send a letter of warning or, in the alternative, authorize formal hearing and send a consent order with a civil penalty in the amount of $1,000 for violation of TCA 62-32-304, paragraph C.
So the complainant is the former qualifying agent. And he has a responsibility to report that he's no longer there, right? So that was never done either?
Yes, it was, but not
Timely?
Timely. Okay, then they contacted the office to tell me they had lost their qualifying agent. Try to appoint someone. Okay, they had so long to do that. It was my understanding to hire someone or try to appoint someone, and that didn't work out either. So we had to.
But in the interim time, the respondent did at some point file with our office that they were without a QA and were trying to find one.
Telephonic. I never received any correspondence from them, but they did call the office.
Was this before or after the complaint was filed?
Oh, no, this was before the complaint was filed. Before the complaint was filed.
Are they actually operating an office in Chattanooga at this point? It sounds like they're operating out of Nashville.
I think what they did, when they called and explained it to me, they were closing down that Chattanooga office and all the work was coming out of the Nashville office, which is licensed and has a DQA.
They were trying to get it done correctly.
They attempted, yes, sir.
Yeah. Make a motion that in this case, after hearing all the facts, that we follow a recommendation of sending a letter of warning.
I second.
With no civil penalty, though, or with the penalty?
I'd say without penalty.
Okay.
Okay, we have a motion by Mr. Harvey, a second by Mr. Cockburn to send a letter of warning to this company without any civil penalty. All in favor, voice by saying aye.
Aye.
Aye. All opposed? The motion carries.
Number 4, case number 2018-006521. The anonymous complaint alleging respondent company is not licensed in advertising to install security camera systems on a website. Respondent is a manufacturer of wireless self-monitoring security systems and offers the product on their website. Respondent does not install or monitor the system. The complaint also involves an individual that is offering the respondent's system through an active licensed company. The individual is the active registered employee of that company. This individual stated that he is only selling the products of respondent and contracts with 2 licensed technicians that install the systems if needed. Recommendation is to close.
So they are being sold by the respondent company?
The respondent is a company that has a website where you can buy a monitoring system or have your TV fixed or computer fixed. Sell self-monitoring cameras where you hook it up to your phone, laptop.
I guess I'm a little confused or lost on if they're selling it and then subcontracting it out, I would think that would be a violation. If they're just selling the part and someone else is installing it completely separate, I wouldn't see that as a violation, but I don't entirely clearly understand how it goes.
The respondent themselves are just selling the parts. They're just the manufacturer of the parts. The individual that is buying those parts through his company is then selling those to the consumer and having them installed by other licensed electricians. The complaint itself is actually against the respondent website.
He doesn't appear to be doing anything wrong. But you've got a guy that's buying a do-it-yourself system that's unlicensed, selling to other people, and then having licensed people install it.
The person buying is licensed.
Okay.
He is just not actually installing.
The person buying it is licensed and he's having someone else that is licensed install it.
Yes.
And you feel comfortable that the website is not the one doing any selling. It's not of the installation.
They're not doing any installation or monitoring.
But are they selling the installation aspect of it?
No,
Okay.
just the parts.
Make that motion to agree with agree with council.
Second.
We have a motion by Mr. Harvey and a second by Mr. Cockcroft to concur with our council's recommendation to close. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 5, case number 2018-00142991. This is also another, it's associated with the last one. The complainant alleges a respondent company is not licensed in advertising to install security camera systems on a website. Respondent is a manufacturer of wireless self-monitoring security systems and offers the product on their website. Respondent does not install or monitor the system. The complaint also involves an individual that is offering the respondent system through an active licensed company. The individual is the active registered employee of that company. This individual stated he is only selling the products of respondent and contracts with 2 licensed technicians that install the systems if needed. And recommendation is to close this one also.
So is this a second complaint on the same thing? So
It was, one of them was anonymous, and then another one was a person that saw the website on a Facebook market page.
what I'm confused about is both of them say that they're advertising to install cameras. And if they're advertising it, that's a violation. If they're advertising the install, even if they don't do it.
Right, I think the respondent itself, the website, is not advertising installation. They're just advertising the product.
Have you checked the website?
Yes.
Did you see anything relative to installing cameras on that website?
I did not see anything about installation.
But how could 2 different people reach that conclusion?
Well, it may have been the same person if one was anonymous and one wasn't, but
They didn't reach any conclusion. It was, we think this is going on.
Oh, okay.
well,
It wasn't concretely there.
No. I think it's more against the individual than it is the website.
But the individuals are licensed
Yes.
for CCTV, and
Well, we don't know who the individuals are. We were just told that they are licensed technicians
who, though? Who were you told this by? The
by
manufacturer?
the individual buying the product off the website who is licensed.
Complaints against the person selling the equipment.
The complaint itself is against the website,
Right.
the company that owns the website.
Make a motion to close.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Cockburn to close this complaint. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 6, case number 2018-009421. Complainant alleges she has tried to cancel her contract, but it will be $600 per the contract, and respondent refuses to cancel. Respondent, in its response, states the complainant was under a renewal clause of the contract. However, the account has been terminated and no money is owed by the complainant. Recommendation is to close.
I move we close it.
Second.
Okay, we have a motion by Mr. Cockburn and a second by Mr. Harvey to concur with our council's recommendation to close. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 7, case number 2018-009441. Complainant was told she would receive a refund of $60 when she canceled her contract with respondent. Respondent sent the refund but was returned due to incorrect address. Respondent has since sent the refund back out to the verified address. Recommendation is to close.
Motion to concur.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Cockcroft to concur with their counsel in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 8, case number 2018-010911. Complainant contracted with respondent for home security services. Complainant alleges that respondent voluntarily canceled the monitoring service without her knowledge until the alarm went off and the monitoring service did not call. Respondent contracted with a monitoring service and terminated the contract in January 2018 following a dispute. Respondent informed all of his customers via email and letter that they would need to find another monitoring service. Respondent holds an active electrical contractor's license that expires November 30th, 2019. Respondent produced an exemption from the board dated June 4th, 2003, stating that he is specifically excluded from the provisions of the Act per Tennessee Code Annotated 62-32-305, Paragraph 7, deriving less than 50% of gross annual income from direct sales, monitoring, installation, and or maintenance services of alarm systems. The exemption law changed in 2009 and is believed that respondent is unaware. The recommendation is to close with the stipulation that the department will send a letter to the respondent notifying them they need to reapply for exemption.
Like he's inching his way out of the alarm industry altogether anyway. Yeah. Make a motion to concur with council.
Second.
We have a motion by Mr. Harvey and a second by Mr. Cockburn to concur with their council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 9, case number 2018-011621. Complainant alleges that respondent sent a representative to her home to upgrade the system. The representative informed complainant that the company had changed names to the respondent and that her billing would be $5 less per month. Complainant was billed $39.95 by respondent, but also $44.95 by the former company for 4 months. Complainant disputed with her bank and was refunded the former company's billing amount, but still being billed $44.95. Complainant wants out of the contract. Respondent stated that the representative is no longer employed and would have been fired if they had known about the situation with complainant. Respondent has released complainant from the contract and scheduled to have equipment removed. Recommendation is to send a letter of warning referencing Tennessee Rules and Regs 0090-06-.03 Standards of Conduct and Ethics.
This company had a similar history of complaints against them of this nature.
I do not believe so.
I move we accept the council's suggestion.
We have a motion by Mr. Cochran and a second by Mr. Harvey to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 10, case number 2018-012291. Complainant issued a lengthy complaint with timelines and dates. Complainant and respondent contracted for a home alarm system in June 2017, but issues began about January 2018. Complainant system was showing an issue with the fire detector and battery, making the panel constantly ding. Respondent has sent supervisors and techs out to complainant's house numerous times to resolve the issue. However, complainant alleges the issue is still not fixed. Complainant has since unplugged the panel and removed the battery to stop the dinging. Complainant is upset that she is paying for a service that does not work and alleges that respondent informed her that if she cancels then her monthly billing will increase due to the alarm system being part of a discount package deal. Recommendation is this is a matter of a product failure and contract dispute and to close.
Motion to concur with council.
Second.
Okay, we have a motion by Mr. Harvey and a second by Mr. Cockburn to concur with our council in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 11, case number 2018-012721. Complainant alleges that respondent knocked on her door and told her that her rates would be increasing and another company bought out the alarm company that complainant was currently using. Complainant alleges that salesman showed her an article from the internet to validate. Complainant felt she was rushed into this agreement and wants to cancel, but respondent told her that she had to pay the balance on the 60-month contract. Respondent alleges they have tried to reach out to complainant without success. Respondent alleges there is a recorded call with complainant pre-installation stating that she understood that her current company was still in business and the reason for switching was due to the product being offered by respondent. There is no mention of rate increases or company being bought out. Respondent believes that her previous company is trying to win her business back and telling complainant that she was scammed. Respondent is a legitimate company and alleges that they are trying to discuss the matter with the complainant to ensure her worries. Recommendation is send a letter of warning referencing Tennessee Rules and Regulations 0090-06-.03 Standards of Conduct and Ethics.
How long after was she wanting to cancel? I mean, was this like right away or within 3 days or?
No, this was about a year.
Oh, a good bit of time later.
Yeah. It was about 8 months, maybe 9 months. It started when she saw something on the local news about a report of alarm system scams.
Was the other information true that the other company was going out of business, or is...
No, that information was really on the news story. It wasn't from the respondent, or I think she really just got it off the news.
Yeah, but it says in the report that her rates would be increasing, and another company bought out the alarm company that complainant was currently using. So, I mean, it says in the report that the person that knocked on her door told her that, or...
That's what she alleges. But the respondent says that that's not what happened. They went through the contract that she signed. They went through the telephone survey and questionnaire. But the information that she put into her complaint came from the news story, which the respondent is saying was started by the former company.
I would think that if it was a scam, she would know, she would still be getting a bill from the, I guess she could have canceled, but I was thinking she would still be getting a bill from the other company. I guess she could have still canceled that. My concern is either they didn't do that, and there shouldn't even be a letter of warning, because that would be on the record, or they did it, and they ought to be, it ought to be more severe than that. But you feel pretty confident that it wasn't true, that you feel like the story was somewhat fabricated to get out of the contract,
Or she mixed two stories into one?
I believe a little bit of both. I believe that the respondent did not say that, and I believe she's mixing it up with the story based on what I've seen in the documents that have been provided by both parties.
Was there hard copy left with her, or it was just she alleges they showed it to her and it disappeared?
No, she provided the contract.
She doesn't have a copy of the internet article that she says she was shown, correct?
Oh, I had to go back and find it. The letter was actually sent to the Attorney General stating the story, and I had to go back and listen to the story.
that were even related to any of the companies in this?
No,
I mean, it's not her old company, it's not her new company.
it was neither company.
That didn't have anything to do with that, so. It is a serious thing. I mean, it is a big problem where people, do what's alleged here. And that's what that whole the rules were about. It's just so hard to prove that or to know what's going on.
It really is. I mean, some of them are pretty blatant, but sometimes stories get mixed, and then you have one side and another side saying two different things, and you have to kind of figure it out. But it is a problem when people come in and tell customers, you need to be with our system because this other company is going away, or bought that company. Yeah,
It's right. It's kind of a mixture of the two. They didn't say they bought the company. They said that who she was using got bought, and they would like to now have her service. So it's not really where someone got slammed, where they were just told, oh, we bought your company. Because they would know if that was wrong, they'd know that right away. They'd still get a bill from two places.
if this company that they were talking about was bought out, it would be on the news. It's a very big company.
So if that was said, then that wasn't true, is what you're saying?
Do we have definitive proof either way?
No.
I would just hate to see a company get a letter that would be in their record if there's no definitive proof.
It's the letter of warning is just that. It's just advising them what the law states in case there's situations, in the future. We do that quite often. We send a letter of warning that if it's an iffy type situation.
Instruction.
Yeah.
We just want to make sure that they're not out there telling people
Right.
this information. And that's why I recommend a letter of warning.
So has this company had a similar complaint in the past against them of this nature?
I don't believe so.
I see there's a previous complaint with a $500 civil penalty, and I was just wondering if it was of the same nature.
It is not of this type of nature, no.
I make a motion to concur with the recommendations of our council.
We have a motion by Mr. Cockcroft. Do we have a second?
Second.
And a second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 12, case number 2018-013-891. Complainant is in the process of selling her house. Complainant alleges that the monitoring provider will not terminate the contract even though complainant has offered the termination fee. Complainant alleges that respondent informed her that she will need a family member or friend to resume the contract. Respondent says that complainant received the system at no cost or labor and signed a 36-month contract in October of 2017. Respondent also states that complainant has made 4 payments and still obligated on the contract. Respondent has offered a discounted termination fee, however, complainant has not yet responded. Recommendation is this is a contract dispute and to close.
Motion to concur with council.
Second.
Okay, we have a motion by Mr. Harvey and a second by Mr. Cockcroft to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 13, case number 2018-016-371. Complainant alleges they switched services to respondent online. However, respondent will not show up to install the system. Complainant now wants to terminate the contract. Respondent has released complainant from the contract and refunded any deposit made. Recommendation is to close.
Motion, we agree with council.
Second.
Okay, we have a motion by Mr. Cockburn and a second by Mr. Harvey to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 14, case number 2018-016-501. Complainant alleges unlicensed activity of the respondent after it installed a system at the local schools. Complainant was concerned for the children and staff that the system was not properly installed due to no license. Complainant happens to be a QA for another alarm system company that lost the bid, and wife works at one of the schools. Respondent states that they possess a valid S-low voltage license and was assured that they were adequately licensed since the school was monitoring the system. Respondent admits that they provide hardware and software as well as installation if requested. Recommendation is to send a letter of warning and instructions for obtaining an ASC license.
What's the normal for an unlicensed activity? What's our normal?
Isn't the minimum $1,000?
It is a minimum of 1,000.
Yeah.
I think unlicensed activity is a big deal.
Okay, let me, if I can, explain a little bit more about this one. We got a telephone call from the school system. They said they do S low voltage, which falls under the contractor's board, even though you are low voltage. They were given erroneous information by one of our staff members and told they did not need this license. School called me, and then the individual who filed the complaint also called.
I remember discussing it before.
With you and I, yes. I believe it was when I called you, but
I thought we heard it at a board meeting or something, but maybe not. Okay.
I called you, to get advice whether they did or not, because it threw their staff off when they said S low voltage, which meant really actually nothing to us. The individual is not a CE contractor, so they will not fall under the exclusion. So they would have to have an alarm license.
What did they install?
They were changing from a analytical system to a different type of a system.
Fire alarm or burglar
No,
alarm?
it's, I believe it's more like that face recognition.
I believe it's more face recognition software.
A part of CCTV?
Yes.
So actually, we feel like they did install it with good faith because they were told they didn't need the license. Stuart and I have talked about this. We need to tell them at least they do need to get the license. We feel now that they do have to have a license. But the system is already installed in the system.
You feel like they were given
Oh, I know
wrong
they were.
information?
Yes, sir.
Okay. Well, that makes a big difference to me then. And it was an honest mistake, but, okay.
And also, the company has reached out and asked what do they need to do to make sure there's no problems in the future.
I'll make a motion to concur with our recommendations of council.
Second.
Okay, we have a motion by Mr. Cockcroft and a second by Mr. Cockburn to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
These cases are being represented. Number 15, case number 2017-078-531. This complaint was opened by request of the board in December of 2017 meeting after hearing the previous complainant 2017-057-981. Complainant alleged that respondent was performing an upgrade to a hospital's fire alarm devices on August 28, 2017, and that respondent was unlicensed. Respondent responded to the previous complaint and stated they were not installing the system, only furnishing materials for the installation. An investigation was requested. The investigator determined that a licensed company, respondent in this case, had employed 2 individuals to perform the work. One of the workers is listed as an applicant and one is not listed at all. Respondent states that he never received any paperwork back from the state on the missing applicant. Respondent stated that apparently the paperwork must have become lost. Both applicants have been properly registered as of January 8, 2018. The updated information is respondent submitted applications for the 2 alleged unregistered employees before the hospital project. Additional documents were needed from respondent, and instead of sending the requested documents, respondent sent new applications. The new applications were submitted after the hospital project. There was no violation at the time of the project. The new recommendation is to close.
I make a motion to concur with our council's recommendation.
Second.
We have a motion by Mr. Cockcroft and a second by Mr. Cockburn to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 16, case number 2017-06-0071. This is an industry complaint. Complainant alleges that respondent advertising on Facebook to install security cameras without a license. Respondent responded to the complaint and states that he does asphalt sealing, however, installed a self-monitoring Samsung security camera from Sam's Club that required no monthly fees or monitoring for his neighbor. Respondent states the complainant is a competitor who is trying to create confusion about his business. Respondent states that he has a business license and mainly does asphalt sealing and pressure washing. Updated information. Respondent states that he helped his neighbor install a wireless door monitor and thought it was fairly simple, so he added it to his business card. He has recently agreed to take off the offering security cameras on his business card and Facebook page. He mainly does asphalt sealing and landscaping jobs, but is sort of a jack-of-all-trades guy. The new recommendation is send a letter of warning and close.
I'm not persuaded to change that.
Really? And have you verified that the advertising was taken down, or?
This is just a recent event this week, but
Okay.
as of now, I do not believe it's taken down.
As far as the camera goes, we have no evidence to indicate that he's done any work for anyone other than just help his neighbor out, put one in.
Yes.
So there's really no violation other than what little advertising he may have done on a business card.
Exactly right.
My concern is that he had, I understand it's his neighbor, but he put it on his business cards with the intent to install cameras
And on a Facebook page.
and on his Facebook page.
And it's not been taken down.
No, his business card is actually the page. Right, it's the picture on his Facebook page is his business card that has offering security cameras. And he just goes to Sam's Club, Walmart, and buys the wireless
Still.
monitoring system. But there's
Still
no
is-
evidence that he has done this except for installed it for his neighbor.
That you know of, but he's still advertising and he's still done it, which is a violation of the law that he's installing CCTV cameras without a license.
We know that he is advertising.
Well, he's admitted to one.
To one, yes.
Well, in the initial response, he says that he installed a Samsung security cameras from Sam's Club, but then the other response is now saying it was just, what does he say? I mean, I get the impression maybe it was like a video doorbell. Sounds like he's
A
also
CCTV system from Sam's is a CCTV system.
but that's
It's not a doorbell.
Everybody install it? I mean, if I go there, can I?
If you're the
install it?
homeowner-
If you're the homeowner, yes.
If you're the homeowner, yes, but he's running a business and advertising that he installs them.
at face value, it sounds like it started innocently. Maybe he helped his neighbor and he thought that was easy, so he added it to his business card. But it also sounds like he did a doorbell, and then he's also saying he does security cameras from Sam's. That's two different things. If it's
Where's the doorbell coming in? Am I missing
that's on
something?
the
In the update section.
What did he say?
Oh, a wireless doorbell monitor.
He thought it was fairly simple, so he added it to his business card.
He has been advised of what the law is and what he is supposed to be doing, assuming he did not know before.
He has been advised, and he states that his main job is asphalt sealing and landscape jobs and pressure washing and things like that. He admits that he helped his neighbor and thought it was easy, and that's why he put it on there thinking he can make some extra money.
I'm fine with a letter of warning, but if y'all want to bust the dudes,
My only concern is his original response is that he's installing self-monitoring Samsung security cameras from Sam's Club. I mean, he's admitted that he just helped my neighbor. That's a concern. I mean, in an industry where we govern installations, he did an install. This is kind of expanded out, but if I get caught drunk driving, well, I only did it once.
I make a motion that we stick with our original decision, and, if he wants to file for a formal hearing or whatever, then we'll go from there.
I second.
which was what?
We stick with our original decision. If he wants to file for a formal hearing, he has the right to do
$1,000
it.
civil penalty.
Yeah, we have a motion. I made the motion, and Mr. Coburn seconded it. All in favor, voice by saying aye.
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 All opposed?
Aye.
The motion carries.
Number 17, case number 2017-057-241. This complaint was presented to the board initially in December of 2017, with complainant alleging that respondent fraudulently obtained her business by indicating the respondent upgraded her system following a merger of the companies. The board authorized a consent order and civil penalty of $500 for violation of Tennessee Rules and Regs 0090-06-.03, paragraph 2, subparagraph F, standard of conduct and ethics. The respondent submitted to the legal division a copy of the April 2017 welcome call involving complainant. In the call, complainant acknowledged that respondent was an independent company, not owned or affiliated with any other alarm system company. Complainant indicated in the call that she was a current customer of another company and was not being billed by another alarm company. Respondent stated that upon receipt of a telephone call by complainant, the safeguards to avoid confusion about affiliation were explained, and respondent indicated the company would be willing to consider buying out complainant's contract. Respondent's next communication from complainant came in the form of a Better Business Bureau and Division of Consumer Affairs complaints. Once those complaints were received, respondent investigated and refunded complainant and terminated the agreement on June 7, 2017. Additionally, respondent terminated the employment of the sales representative involved in this transaction. The revised recommendation is issue a letter of warning to respondent regarding Tennessee Rules and Regs 0090-06-.03, paragraph 2, subparagraph F, standard of conduct and ethics, and close.
This is several cases we've had today in this legal report that all basically are the same complaint. Is there not anything that can be done to these companies? Are these all the same companies, or are these different companies?
They're different companies.
Something needs to be done, because it seems to me they're almost committing a type of fraud or whatever, where they're going to people and almost scamming them to where they don't understand what's happening. Case, there must be some validity because the respondents terminated the sales representative.
I would agree with
Excuse
you.
me.
First thought when it said before they had terminated the contract, I think, or they let her out of the contract, that it was like that might not in and of itself be an admission of guilt, because it may be easier to do that than to fight it. But then when you've also let the employee go, that's a little bit more telling.
It's true. Make a motion, we stick with our original decision.
Second.
What was our original?
$500 for code of conduct. Standards of conduct and ethics. I think it's at the top of the sheet.
I'm sorry, I misunderstood.
Ron, your second. I don't know. He seconded it, but I don't know if he's going to withdraw it or not.
Yeah, I thought you were speaking of the new recommendation. I'm sorry, I do withdraw.
Excuse me. I think
Of course, not to try to sway the board against their decision. I will say that I personally listened to this welcome call. This was sent in. This is why it's being represented, because I had those same reservations as you did in December of 2017. But I've been in contact with their legal counsel, and that's where the additional information came. They provided me with a copy of the welcome call. I listened to it, and that was where the complainant in a separate company, she knew that they were not affiliated, and she still wanted to proceed with Respondent Company as her alarm provider. I can't speak to why they terminated that sales representative, of course, but that information was provided to me, so I provided it to you all.
That's what I wonder on some of these. You know, they say they have calls, but you actually heard it, so you have a better feeling of it than we do. Because I wonder what is going on. Is someone saying something beforehand and saying, oh, well, you've got to answer all these questions or I can't do it. But then they're knowledgeable of it. If they do that, it's like they're answering the questions. They're agreeing to it.
I have a question. Did they knock on her door as her first contact, or was it with whatever this welcome call is, where they taped it?
I believe it was a door-to-door sales call. And so then right before they enter into the contract, they have to contact, I guess, the corporate office or whomever, and acknowledge all of these different scenarios that it is an independent company pressured into signing this contract before they begin with the auto debit.
It's an attempt to provide proof of non-duress.
Sure. Yes, sir.
And it's also an effort on the company's part to make sure that it's not going on. It's a double check on their salesperson. And this is against the company. So even if that happened, I guess the company was making a diligent effort, it sounds like, to prevent it. I mean, the salesman would have had to say, had to have this line.
We're going to ask you these questions.
And you've got to say,
right.
That's not, why would someone do that if they didn't believe it?
Our issue is we would have no way to prove that
Right.
did or didn't happen.
I move we go with the revised recommendation. It seems as though the company did try to prevent anything like that happening. The complaint is against the company.
Second.
Okay, we have a motion by Mr. Cockburn and a second by Mr. Cockcroft to concur with our council's revised recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
That is the end of the legal report.
Thank you very much. We're going to take a 15-minute break. Meeting back to order. I think the next thing on the agenda are the appearances.
Yes, ma'am. We have 2 appearances today, and I have already asked both of them to sign in. So the first one is going to be Eric Seedoff, if I pronounced that correctly.
Yes.
All right. If you would, you need to look at Exhibit A. And Mr. Seedoff, they have not seen, well, I believe they have. The information they have right now, they haven't seen. But I believe you were asked to come before the board at the last meeting. They had some questions about charge or charges. So if you'd give them just a moment to review again.
I'm sorry? S is in Sam, E, D is in dog, O, R, F is in Frank. First name is Erick.
If I'm not mistaken, Scott, I believe you asked this gentleman to appear. Okay, Mr. Cedar, would you, do you have a copy of that, what you gave me?
No, I not on me.
Okay, would you mind, there's one charge on his record. Would you mind, you can go ahead and speak to the board if you would.
Back in October 1992, I had broken into a moped scooter shop and stole a moped. I was arrested leaving the building, a building property. I pleaded guilty to the breaking and entering and auto theft, which is due to the moped being a motorized vehicle. And I served 2 years probation on that.
Explain a little bit, I guess, of the circumstance of what happened or what led you to that. Or...
I was young and stupid.
I mean, our concern, what bothered me, you know, I guess you felt like it was a higher charge because of auto theft, but it was, and you were saying that it was really a break-in, and that's what we do. I mean, we put in burglar alarms, so that's very concerning. That's not to say that you couldn't have redeemed yourself, but without more explanation and where you are today, that bothers me.
At the time, I felt I needed a mode of transportation because I didn't have a car at the time.
How old were you?
I was 20. And I felt that was a good option at the time. Again, like I said, young and stupid. I've stayed out of trouble since. I've held management positions. And I have worked in this business for about 8 years now up in Indiana and pretty much kept myself clean. I don't want to go back. So, you know, I take that very seriously. You know, even if friends ask me to do stuff, I don't because it's my livelihood.
I guess, I mean, can you tell us a little bit about yourself today and, you know, how are you? I realize you were 20, but give me a little background. I mean, where are you today? What's different about from then? And
back then, I had no direction. And I was just working mostly retail stuff. I had since gone into restaurant business, all aspects of it, serving, cooking, went into management. About 10 years ago, when my son was born, I decided I need something more concrete, and I went to Lincoln Tech to do low voltage service. And I've been doing that ever since, mainly because I want to make sure that I provide for him, and he knows that, you know, this is what you're supposed to do.
And I'm not sure where you said you were in Indiana, or you?
I live in Greenwood, Indiana. It's just south of Indianapolis, Indiana.
And do some work in Tennessee, or would like to?
We are getting ready to, so we want to make sure we have all of our stuff in line before we do it.
When you were on it says you served 2 years probation. Any violations on your probation, or was this your
No.
way? This
No,
was your
I
wake-up call.
I made my meetings and I made my payments, and that was it.
You made a statement a while ago I picked up on. You said, I have friends that still ask me to do things, but...
Well, I mean, as in they ask about putting in alarm systems, or I had a friend of mine that was getting ready to start a business, asked if I would come in and wire some fire stuff. And I tell them no, because if something goes wrong, that's on me, and I'm liable. So I tell them no. I usually refer them to my company where they can call and, hey, can you come out and do a quote, instead of me going and just doing stuff.
So you've been licensed with your company in Indiana since 2013, is that correct?
Indiana doesn't require licensing. I am a licensed fire technician and inspector in Ohio as well, though.
What all do you do in your work?
I put in fire alarm systems, nurse call systems, access control, whether it be local, as in maglocks and a keypad, or a card reader for an entire building, as well as wandering systems. Those are mostly like in nursing facilities. A resident will wear a tag, and when they get too close to a door, it will alert staff and normally lock down the door so that they can't get out.
So on your application, it's got job title, position with Alarm Systems Contracting Company as a certified technician.
Yes.
And then date of employment in registered position is September 30th, 2013.
Yes. Before that, I worked for 3 years for a company called Hughes Integrated. That was based out of also Indiana. Trying to remember it was a small town just north.
I believe are you saying that was with the company that was in Indiana when you put that date down? That wasn't when you started doing any work in Tennessee?
No, I haven't.
It's not registered yet.
Yeah, I have not done work in Tennessee yet.
Referencing the fact that it said certified technician, or just?
Well, it just says he's a certified technician, and then that's what I was trying to find out was.
Well, I
where
went
he
to
was
Lincoln
registered.
Tech, and I have the certifications and graduations from there.
Actually, what they should say, date of employment and registered position, is no, because I'm not in Tennessee yet. When we say registered position, we mean Tennessee.
That's what I was trying to figure
Oh,
out.
I apologize. No, I'm not certified in Tennessee. I just have the certifications from the Lincoln Technical College that I went to.
So you graduated from Lincoln Tech
Yes.
in 2013.
No,
Thereabouts.
20.
You started to work for the company in
Company.
Indiana in 2013.
In 2013. I graduated from Lincoln Tech in 2010.
Has the company become licensed in Tennessee?
When I looked at the report, the answer was no. They may be as of today. I did not look today.
How would they apply for is this for a qualifying agent or a registered employee?
Registered employee.
How would,
He wants to make sure he can qualify in the state of Tennessee before they come in
oh, okay.
as a registered.
I didn't know you could do that. I know you could necessarily apply as an employee without a licensed company. Okay, okay. Do you have anything you'd like to add, or do you?
I can't speak to Eric's record.
Introduce yourself, please.
My name's Joe. I'm the qualifying agent for
Joe,
Safety
last name?
Buckley.
Okay.
I can't speak to Eric's record. We knew that when we hired him, we didn't do background checks, but Eric offered the information voluntarily when we did the interview. Had nothing but good, positive things from Eric. He's been a great employee for us, probably one of my best technicians and installers. And
How long has
Make
he been
sure
with you?
sorry, he's been great for us. I'm sorry.
How long has he been with you?
Since what you put down? Yeah, 2013 was with us, yes.
I think I understood you to say from the audience that your company is now registered or licensed in Tennessee.
That's correct.
Okay.
It's a fairly new license company. I believe in 17.
Make a motion that we grant Mr. Eric his registered employment.
Second.
We have a motion by Mr. Harvey and a second by Mr. Cockburn to grant this individual his registered employee status. All in favor, voice by saying aye.
Aye.
All opposed? Congratulations, and thank you for coming before us.
Thank you.
I think the next one on our agenda is another appearance that we have, and I believe that's Stanley Hill. Ask Mr. Hill to come in to review his record as well. We need to give them just a few minutes to look. Not only have his application, you do have letters of recommendation as well to review. For a new board member, I will tell you, Glenn, I show you everything that's in the, try to show you everything that's in the packet now, except for the criminal record. That is not public record, and if I shared that with you, that would be secondary dissemination, and I'm not allowed to do information that he puts in the packet or with his application, you can see. Basically, what I've saw on Mr. Hill was a 1997 criminal mischief, 2 counts, guilty, which he got intermediate punishment program. I did not know what that was. November the 3rd of 97 was theft by deception, forgery, probation, reckless endangerment, guilty, 2 years, agricultural vandalism, guilty, burglary, guilty, receiving stolen property. Those are the documents that you have in front of you.
Well, first off, my major concern is you've been in and out of the court system all the way up to 2009. According to the documents, you failed to pay your fines all the way up to 2009. I mean, being upfront, that's my first concern. When you're dealing in an industry where people are counting on the person that comes into their residence or their business. Concern for me. Just tell us a little about yourself, where you are, how you got where you are, etc.
As relation to the issue that of the criminal activity,
You need to speak into the mic.
I'm sorry.
That's okay.
So as regards to that, I don't generally make excuses. What I did was wrong, and I paid my trying to live a better life, and I've always did that. As regards to what you addressed, Mr. Cockburn, I've had trouble prior to recently. I would say in the last maybe 10 years, I've always had trouble finding reliable employment. So generally I had to make decisions on what I could pay, whether it was, car insurance, whatnot, and I have gotten behind in fines, and that is true. And I have had to go to court and explain that to them, and I've always kept caught back up. But I have not had any trouble since I've gotten reliable employment, nor have I done anything, I guess, inappropriate to make up money, to do anything to catch myself up on what I need to do. As regards to where I am today, upon my release when I was younger and I got out of prison, I successfully completed my probation. I went to school. I have an associate's degree in electronics technology. I've worked in hospitals. I volunteer in hospitals. Well, at least I did in Pennsylvania. I moved down here in December 8th. I was the Tiger Scout leader for my child. So I've done that. I've done a lot of school activities that I do for my kids as well as my family. I am a family man. I have a wife and I have a son. My son's 4. My stepson's 11. I've held this job here with Simplex, which is now JCI, for about 3 years. I am licensed in the state of Maryland, and also I have my low voltage license in the state of West Virginia. Pennsylvania doesn't require licenses, but I've worked exclusively in Pennsylvania on fire alarm, a little bit of access control, and minor CCTV, but I have done work on them as well. Like I said, I don't make excuses. I mean, what I did was wrong. I was failing decision-making skills. Mainly, my main issue was accountability. I've always blamed everybody else for my own falling, my own mistakes. It took me many years to come to terms with that, and then until I realized that whenever I make a mistake, it's not society's fault or my family's fault, it's my own fault. And I think from there, I've actually grown as an individual and as a person to where I don't blame anybody else for anything I do. And Tennessee, and now I'm applying to get here to continue on what I do, and I do fire alarm, security, and
Transferred by the company, or did you?
am working for them, but I have not been doing anything since we got the letter to cease and desist from you guys. But I was prior to that letter, so.
You're in good standing with the company.
Yep, the letters you got are from my previous employer in Pennsylvania. I have one that was my hiring manager, who also is the Baltimore supervisor. The other one was my current supervisor. His name is Ron Malalaskis. And then also the guy that trained me, my training, I guess he was a coworker, but he was the guy that trained me, my senior technician. Qualifying agent from the company.
Donald Trammell, Ryan is my middle name. The license is under Donald. I'm the qualifying agent for Johnson Control Fire Protection here in Nashville. Our company for the past 3 years in Pennsylvania with exceptional recommendation. Did pass all our background checks that our company ran at the time of hiring, and he passed them on the background checks we'd have ran when he transferred here to Tennessee, as well as any screening. I'm not sure why it keeps cutting in and out. I apologize.
Just push
we get
the
really
speak button
close.
down.
How about that?
Keep it down.
He has passed all background checks that we provide, that we've done. Ours typically go back 10 years, so obviously it didn't pick up anything that was that far back. He has been an exemplary employee while he has been here up until we got the cease and desist. He's very thorough, very knowledgeable. Our other technicians get along well with him. Customers get along well with him. He probably details service work tickets more so than any other technician we have. So, which it does come in handy, but can take a little while to get through everything sometimes. But I would do speak for his character and his work ability and his work ethic. He is a very outstanding technician, actually, for us.
Make a motion on the information that we've gathered here today, the letters of recommendation that we grant Mr. Hill his registration.
Second.
Okay, we have a motion by Mr. Harvey and a second by Mr. Cockcroft to grant Mr. Hill his registered employee status. All in favor, voice by saying aye.
Aye.
All opposed? Congratulations. And thank you both for coming in.
Thank you.
All right, Mr. Hill, you'll be hearing from us as well.
I'm just curious. I'm not.
It's a valid question. We understand.
Money's money.
Well, no. I mean, I'm still getting paid, but it's more. Can I go on customer sites? I just want to.
Busy.
Yes, sir, because we'll go ahead and work it this afternoon.
Thank you.
We're going to work the file.
Thank you. Okay, is that the last of our appearances?
Yes, ma'am, there was only 2 appearances.
You want to go into the administrative matters, or what's your pleasure?
Yeah, that'd be fine, if you don't mind. I believe the first thing that we're going to go into, that's my section there, will be the monthly report. There's not really a lot to report on the monthly report. You have your February and your March. We start with the Alarm Contractors Board. You can see there were still positions open, and those 2 positions have been filled. Cockcroft is coming up on December of 2017.
It's already expired.
Oh,
I think we're
I
in
apologize. I'm
2018.
trying to get.
Just holding on to you.
I guess so. All right. I haven't heard anything from the governor's office. So you continue to serve, and thank you. Oh, and I did want to mention in that respect that we did have a seminar in Memphis. We had one in the morning. One day we had one in the morning and one in the afternoon. And when was the alarms? We broke it out with alarms, all 4 professions. There was 4 of us that went. We had a good turnout. Of course, I did speak, and then we were there to help people learn how to onboard, find out what problems they were having, because we see the problems on our side, but we don't see the problems on your side, on their side. We had several alarm companies that stayed over, and we did assist them. I also told them if they're having any particular problems, we would be glad to come to their office and assist them as well.
Were they having any problems with the filings or?
There were several that did not know how to work the system. Because there's 2 steps that you have to take. You have to onboard the first time and get an account. Then you go in and do the account. We are still experiencing, and there's not anything I can do about it. It will time you out. You need to have all your information together when you sit down at the computer to do it. And even then, sometimes it will time you out. That is a problem that we're addressing with our STS people. But we didn't get anything basically but very good feedback. There were some, yes, there's problems that we were going to need to address. I do understand that. But they were very minor, and some of them are computer related that I cannot help. I cannot change them timing you out. The next drop that they have on our system is supposed to allow you to make multiple payments. This is what the problem. Some of the larger alarm companies sit down with one credit card, have to do Johnny, then I have to come out and do Mary. However, I was told that in this drop, they've got, hopefully it's going to be fixed where you can make the multiple payments. We are looking forward, and that should be a very big help for some of our larger alarm companies and other companies as well. We will be having another seminar in Pigeon Forge, Chattanooga, and Nashville this year. So for everyone, and unfortunately, if they're having particular problems and they haven't come to the seminar, I don't know what to tell them. But like I said, I've sat down with management, and if you call me, you say I'm having problems, we will come to you to help you, because this is what we have to do. So if you know if anybody's having any problems or anybody talks to you, just call me and we'll be glad to assist them.
Everything's online now, right?
Yes.
Because there was one thing earlier, somebody was talking about sending in an application in one of the complaints, I think, or one of the responses, but because I was wondering about that at the time, but everything is online.
You will not find an application online. All of them have been removed. I do still have some companies that have some old applications that are sending applications in that we have paid personal visits to or made telephone trying to encourage these. I mean, I just can't take a stick and beat you and make you do it. But
you could return them, I guess, but you are accepting them.
You say there's no longer any applications online?
Paper
Like
applications.
to print a paper application.
Oh,
Everything
okay,
has to be
'cause
done
I was sitting
electronic.
thinking, I thought that's what we were doing was electronic, but we don't have any online applications
No, I mean,
anymore.
if you call me and say I'm starting a new business, where do I go online to get this application? I'm going to send you to the website, because you're not going to be sending me a paper application.
Okay, next.
Right? If you would take the next item is going to be the budget. We'll take a look at that rather quickly. All I have as of the date is as of January the 18th. Was $26,309 is what was taken in, and the total. Those are total. I'm sorry. That was your expenditures. The actual amount afterwards was $18,106. You have a total of $128,381. Still in the positive. Oh, excuse me. Beacon Center. I don't have any legislative update. other than the apprenticeship?
Yeah, none specific to the alarm board, but there were a couple of bills I wanted to bring to the board's attention. They don't have public chapters assigned just yet, but they have been passed. The first is it's known as the Fresh Start Act. It'll be effective July 1st of this year. And just to summarize, this act requires that any application denial that is denied based on a criminal felony or misdemeanor, there has to be a connection between the license they're trying to obtain and the felony that's causing their denial, or the conviction that's causing their denial. So we have to be able to make that connection and give them notice that we're denying it for whatever charge we've denied it for, and be able to make the connection. Yes.
So in the past, where we've been able to be a little bit vague with poor moral character, you're saying
Poor moral character is still something you can cite to, but if it's specific to we need to be able to say they were convicted of theft in 2002, which is connected to the alarm license in this way. We just have to be able to say that to them. So I did want to bring that to the board's attention. Like I said, that'll be July 1st. And then the second one, Cody and I was just updating her about it. This one goes into effect January 1st, 2019. It's nothing required for the board to do, but you do have the opportunity to establish an apprenticeship program. And if the board decides to go in that way, there are certain rules that we have to follow to do that. But I wanted to bring that to the board's attention as well, should you all decide to adopt an apprenticeship program. And that was all I had.
What would we have to do on the apprenticeship program? We would have to adopt a specific, because it seems like we had something from the National Association or from Electronic Security Association or something that had a proposed apprenticeship program, I believe.
I'm sorry, but I don't remember that.
It's been some time back. I think it was, what is it, state?
It'd be the Tennessee Association.
It's both.
the
It would be the ESA, which used to be the
Yeah.
NBFAA.
Well, so this particular law, it doesn't tell you how to establish your apprenticeship program. It just says that we have to, grant a license to somebody that has a high school education, has completed the apprenticeship program. However, that board decides to lay it out, whatever those requirements are. But it, like I said, it gives kind of a skeletal guideline of establishing an apprenticeship program. There was some talk at the very beginning about the age that you had to be an apprenticeship, but through amendments, that part is gone. But it's given the board the option to establish an apprenticeship program.
My understanding is one of the main purposes would be with prevailing wage for some companies. If there was an apprenticeship program, I believe right now, if it's a prevailing wage job, it goes to like the electrical contractors' rates and apprenticeship program.
I'm not sure.
In our industry, since there currently isn't an apprenticeship program in Tennessee, if you do a job that has to pay prevailing wage, they look at an electrician's wages for the prevailing wage. And even if there's a helper on the job, they have to be paid the electrician wage, which makes it hard to do jobs sometimes. Sometimes it's great for the employee getting the pay, which I understand, but it's hard for the company. And then some employees don't get to work a job because they don't make that much, and they can't afford, the company can't afford to pay them. But I don't know what would be involved in us doing the apprenticeship program if it's a lot of.
And I will say that this particular amendment of the law does not speak to how we set forth the wages and all those things. If that's something we wanted to promulgate in a rule or something,
I don't think we would set the wages. I don't think that's.
Right.
I think that's something that, though, if there's an actual apprenticeship program, that it lets you have an apprenticeship wage.
I can tell you, Davis-Bacon, federal government, they do not differentiate. There's a job that my company is working on now that the electrician we work with has somebody who is still in school. He has to leave by a certain time to make classes, and he still has to get paid the prevailing wage for the occupation. For them, their labor, as their definition is, is basically a gopher. If the minute somebody picks up a screwdriver and turns it, they're now an electrician.
Well, and that's what I was told. It was a long time ago that I did a job somewhere that was prevailing wage, and we were told that, I mean, because I had a helper that I then couldn't have work on the job. And I was told he could sweep up, but if he picked up a screwdriver or touched a piece of wire, he couldn't work the job. But I was told that if there was an apprenticeship program, he could have been paid a different wage. But
Now, as far as state prevailing wage, I'm not as, we do a lot of government jobs, so I can probably quote inside out Davis-Bacon.
and I think that's what it was referring to. This was like a state university, but their rules, I guess, could have been different.
And I think the purpose of this is just another path to licensure. So it says that if the board establishes such a program, the person shall be granted a license if they have in high school education, have completed the apprenticeship program, have passed the test, and have paid the fees. And then we will grant them a license. So it's another path to licensure.
As far as a qualifying agent or just the registered employee, because they'd have to be the registered employee even to be the apprentice.
Well, my concern is that, I mean, if we go by just those rules, you know, we have these juveniles that are, you know, bad history. Can we set the precedence of mandatory criminal background checks? And the problem you run into with that is juvenile records are sealed.
Right, and so just to make it clear, like I said, this is not specific to the alarm board. This goes to all. It's a state law that's being implemented. The parameters around an apprenticeship program, should the board decide to establish it, is something that we'd have to decide and put in rule and all of that. So whatever those parameters are for the apprenticeship program would be set by the board. This is just telling the board a license would be granted to an apprentice once they've completed these 4 steps. And that apprenticeship completion would be determined on what the board decides an apprenticeship is.
Well, my question is, why would an apprenticeship be needed if you have the registered employer who just comes in, makes application, does fingerprints, background check, pays the fee, and that's it?
I don't think in our industry,
similar to the
in this licensing, and for this board, I don't think an apprenticeship program is necessary. I thought that one of the only reasons was prevailing wage, and maybe that's not even the case. So, but our industry is different, I guess, than some of the others. Maybe an electrician, where they don't have to get a registered employee license to start with, but that helps them get to the master, I guess, the electrician or master electrician. But there's not that hurdle in our industry.
Right, and that's why I said I just wanted to bring it to the board's attention. Again, it's not specific to the alarm board. Should that be something the board wanted to discuss, I wanted to tell you about the law that's going into effect.
Thank you.
Next.
Step aside here. I believe next on the agenda is an applications review. I don't have any actual application. They're criminal records, and that's down below. The next one is going to be discussion, if you would look at that. The first one is Reed. He sent me the email that you're looking at, asking me questions. He says the following scenario would be if we were creating a brand new company and not associated with any current contracting license or QA. If our company never steps foot inside a home, a business, or a property, the consumer orders a DIY security system from a mall or website offer. There will not be a physical location for them to visit and purchase. Number 3 is the consumer owns the equipment purchased, and if it fails, they return it by mail, if under warranty. Or they discard it and order more. A tech will never come to their home for any reason. When the consumer receives the security equipment by mail, it will be activated to be monitored by a central station. If they cancel service, they can still use the system as a standalone without monitoring. Our company does not actually do the monitoring. The consumer would pay us for the service, but we would sub it out to a central station company that is licensed in Tennessee for monitoring. So the
This is
question,
back to the same thing where they're involved. They're, if they were using a third party and not in any way involved in the monitoring, then that would take care of that.
Collecting
But
fees.
They're collecting fees, which puts them into the monitoring loop. So, yeah, they're going to have to be licensed from that aspect.
Their last point makes it clear that the customer will pay them. It says the consumer will pay us for the service, but we would sub it out. That requires licensure.
right, for them and for the person they're subbing out to, because all
Correct.
parties have to be licensed.
Correct.
Right.
Okay.
And not only that, one other thing it says, are they going to have like customer service technicians available to advise a person on the type of system they need, the sensors, whatever the system might need?
Wasn't it over, I think they're saying it's all by mail, isn't it, or a website?
That's okay. I can say it's by mail, but if I've got, I can mail it out to you. But if I'm offering technical support on it,
Oh, I don't know, it just says the tech will never come to your home.
Right, but that
They
doesn't
just say
mean
you
that,
can't
that
call
doesn't mean
them.
they're not
That doesn't
offering
mean that the-
technical support
yeah,
Yeah.
we're not providing technical support by telephone.
All right.
or any other means.
Then it says, would any of these items described require a qualifying agent? Well, if you're telling me he has to be licensed, the answer is yes. The company would be licensed, so they have to have a qualifying agent. If so, which items would cause that?
Well,
Well, everything he mentioned in his email, pretty much, is what we're saying. Well, I don't think the next one, if this can be done without a QA, we would still need, well, cannot be done without a QA because you have to have a qualifying agent and have an alarm company. It says, please cite applicable rules, regulations, laws, etc. So I believe all I'm going to do is tell them I presented to the board, if that's what you tell me to do, that they do need a license. And I'm just going to quote the alarm systems contractor license laws and rules. And they can read for themselves.
Especially, the 2 points we've brought up, the technical assistance or advising and the fact they've put themselves directly in the monitoring loop. All of the rest goes away.
They can clearly sell a do-it-yourself system over the internet or even in a store. Where it becomes confusing or a little muddy is if they're selling it in a store, they give advice on what they should put into to secure the house. But if they just have stuff on the shelf, they pick it up, walk out with it, all of that's fine. Personally, I feel like they could even give tech support over the phone, not counseling where to put the stuff, but if they can't get the sensor to work, that's my opinion, but you may differ with that.
Well, I mean, but if they go to place an order over the internet, got that live chat box that comes up that says, and they say, that person starts telling them, well, you need this, this, and that.
Right. If they do that, yes, if they're advising on how to secure the property, and if they are if they are charging for monitoring, if they're involved in the monitoring, that to me are the items that.
I still think if you're providing technical support, you are providing installation assistance. We charge for telephone support.
Well, would you consider another manufacturer or Honeywell or someone, Interlogics that's selling products that they would need to be licensed if they're giving tech support to a?
But they're giving to a dealer, not to a home end user. You call Honeywell tech support and tell them you're an end user, they'll hang up on you.
Well, let me try it different then. Do you think a CCTV company or a company that's just selling cameras over the internet, if they help someone set up a DVR, is that a violation? I mean, an end user, someone bought the equipment themselves, and
That becomes more of a programming issue than an installation issue.
right.
But if you're lending tech support in an installation issue, I think that becomes a licensing issue. And how do you prove? Where do you draw that line?
Right. I think there's enough that's clearly needs to be licensed that's there aside from that, but
I think we're just going to get more and more of this. Every meeting we have something that I'm bringing this to you.
Oh, there's 50, 60 on Facebook alone in a day.
It'll get worse.
Okay, so what is the board telling me to tell this individual?
requires licensure.
It requires licensure, and I'd send them a copy.
The laws and the rules for the
Laws and the
okay.
rules.
And we actually asked them to come in, did we not? Or even, I think I had suggested.
Well, this is something different.
Oh, this is not
a
the
different
same-
one, not the
oh.
same one. No,
Oh, it does sound, I thought this was just. the-
that sounds familiar. That's what I said. Every meeting we're having one of these. I mean, I can tell them that over the telephone. In my opinion, as the director, I feel you need to have this license. And then they go, well, let me send this to you so you can take it to the board. Then that's what I need to do.
Okay.
Or we can just ask the gentleman. I do have it's a 615 number, which is local. If you want to see him in person, he could come to the board meeting if he disputes the fact that he needs a license.
I
can
don't think
offer him that.
our answer would be any different, but that's what we had asked of the other. We had asked them to come in.
I mean, he has the right to be heard, so.
This one's, if this is different, this is more clear that this particular person is doing the monitoring. I mean, they say they're subcontracting it out, but they are selling the monitoring service. The other was more vague. They were saying they were just referring them to someone. I thought this was the
There was a
response to
coupon in a
that.
box for
Right.
monitoring or something like that.
So the point of it is they're getting paid for the monitoring service. I'm getting paid for the monitoring service. Okay, I may not be doing it, but I'm giving it the
Right.
monitoring service to
It's
her.
the
But I
same
took the
thing as with
payment.
Lowe's. If y'all remember, Lowe's came in about a year or so ago, and that was their question. They wanted to be the monitoring fees paid directly to them on some system that they were selling in the store. And we told them the exact same thing. If you're involved in the process, then yeah, you have to be licensed. Because they were trying to figure out in general if Lowe's needs to get their license to sell alarm
And there's a
systems.
chance that the confidential information of the customer is going to be stored by the person who is selling the DIY system.
Right.
Which falls into all the other criteria.
It's to protect the consumer from the standpoint, even though they're subcontracting it out, they have access to all that information. I mean, we've had people say that they didn't, but if it's your account and you decide you want to move it to another central station, you've got to be able to get the information to to give it to another subcontractor. But that's the concern, is that to protect the consumer and all of their their passwords, their call lists, those sorts of things, and what the alarm system covers, whether it's just doors or it's doors and windows and those sorts of things. That there's people that haven't gone through the same process, their background check and everything, that have access to all their information.
All right, so then I will be emailing this gentleman back and tell him, yes, he does need a license. All right.
Criminal history reviews.
No,
No.
you have another one that's not on here. Well, actually, it is a criminal. It's different from the other ones, so I wanted to separate this. You don't have this information in front of you, but I will tell you what it is. It's an application to be a registered employee. I have been notified, or in his application, I should say, of a charge. It is domestic assault, but it's not going to court until 2020.
It's not a
Conviction yet. So the gentleman may be given diversion. Well, I said, well, I'm not able to sit here and hold an application open for a couple of years. I need to know what needs to be done with it. We either deny the individual or try to assist them by doing a litigation monitoring. And that's why I'm bringing it to you today. vote on my doing the litigation monitoring, turning it over to Ashley, putting verbiage in there that you can be licensed now, but if you get diversion and you violate probation or you get convicted, it'll be an automatic revocation order. We wouldn't have to go to a formal hearing to take the license.
This person's saying their trial's not coming up until 2020?
They've entered into a retirement order.
Okay.
And it's due to be retired in 2019. It's due to be retired in 2019. So rather than hold his application for something that could possibly be dismissed in 2019, we would, if everything else checks out, we would grant the license now with the litigation monitoring order. If he fails to comply with the terms of his retirement order and that conviction ends up on his record, then at that point we have grounds to revoke that license.
Define retirement order for us.
It's akin to Davidson County's diversion. So we're going to set this conviction aside if you meet criteria A, B, and C, whether that be attend to treatment, stay out of trouble, whatever terms the court sets out. If they meet all of that, they'll come back to court in February of 2019 and dismiss the case. So it's not a full conviction yet that we can hang our denial on, but it's also, not a dismissed case yet either.
This is a applicant for a registered employee, and there's nothing else on their record.
And it comes into you're innocent until proven guilty.
Right.
He hasn't been convicted. I mean, he can be watched. I really don't see how we could deny him because technically he does not have a conviction yet.
But we do have the option to, as far as monitor.
We can approve it
And
with
that's
that
what
condition.
you're proposing
Right.
is do a monitoring on it until the case is retired.
That way, if it's dismissed early, he can let us know that, and we lift. It's essentially a probationary period. If he violates one of the terms of the retirement order and it turns into an actual conviction on that charge, he already knows that we're going to automatically revoke the license for that charge. But like Mr. Cockburn said, we can't really deny him on a charge at this point. I think from my conversation with Cody, I think that might have been the only thing that caused pause in his application.
The litigation monitoring, so Glenn will know, it's putting actually the ball back in their court. They have to notify us instead of me trying to go out there every week to see what's happening on the court system.
What happens
for
if he
him.
doesn't?
I beg your pardon?
What if he doesn't?
Well, that's why we have the order.
Right.
If he doesn't, we're going to
and we find
automatically.
out, we will revoke his license.
Okay.
Right. We won't have to do a formal hearing. We won't have to come back from you. It'll just be an automatic. I'm asking you permission to do the litigation monitoring.
So he's not been convicted, is what you're saying. They're delaying any type of conviction. If he meets the following qualifications, then it'll be dismissed. There's not been a trial.
Yes.
Okay.
I'll need a vote on that.
Yeah,
Please.
we need a motion, please.
I motion we go forward with the litigation monitoring.
We have a motion by Mr. Cockburn to proceed with litigation monitoring on this applicant. Do we have a second?
Second.
And both of the guys seconded it, so all in favor voice by saying aye. Aye. All opposed? Honestly, I don't know. I heard them
Okay,
both at
I'll
the
put
same
Glenn
time.
down and Keith as a second. Is that okay?
Yeah, that'll work. Okay, next.
All vote?
Yes.
Yes, we all voted.
I'm sorry, I did not hear that. Okay.
Yes.
Then I will notify him that, and I'll work it in the office and go ahead and get him approved, and Ashley will get the order together for it. All right. Now, we can scratch through that one, and we have some criminal histories. We have 7 of them. We actually have 8 of them. There's one that you have not, is not on your pad.
Are we starting with Exhibit A first? Okay.
Since we, so Glenn will know, since we only meet every other month, as every now and then we'll have extra things on the agenda because I try to put as much as possible.
Gets all of it out of us that she can in the time that we hear is what she's saying.
Yes, we do. We try anyway. All right, the first one you have is Exhibit A. I took a little bit to work this one up, but I believe what I saw. 70 months reduced down to 51 months with 3 years of probation. Conspiracy to distribute 50 grams of meth and 500 grams of some type of mixture. Is make an application to be a registered employee. Have a letter of explanation about charges in 2006 and 11 and 12. Actually, it starts back in 06 and works all the way up to 12. Was incarcerated in the federal prison camp at Maxwell Air Force Base.
The 2013, I'm just looking at the application currently. The 2013 conviction and the 41 months, there's not a probation. Did he complete the 41 months and then would there have been probation that's not completed? Or?
You don't have probation in the federal system.
Oh, okay. So he would have served the 41 months. So
I think it was like 90 to 95% they have to serve.
I'm noticing a discrepancy in his letter. He lists his dates. The last one he lists is March 20th, 2012, but on his application he has it as 13. Wife who's OCD, I'm learning.
Actually, what it is he has actually the wrong year. 3/20 of 12 is what's on the record. He does say on his application 3/20 of 13, but on the record it is 12, and that's the one where he was the 70 months with 3 years supervision. Got reduced down
to 41. And on his he didn't fill in on his app that he's on probation, but in his explanation, he has
Supervised release. It's usually what they call it.
he says he's been clean for 7 years, but the last conviction was in 12.
I think. 12 years. 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 12 ye what it's saying, if we're selling it or manufacturing it. And use the terminology used. It says manufacture.
Some of his wording is a concern to me too. Having previous members who have had addictions in my family, drugs are no longer an influence or a desire. They're always an influence and a desire.
Package, you also have a letter from the qualifying agent.
Yes.
Don't we need a motion for discussion?
Do we?
Can I make a motion we discuss this?
I think we can discuss and then have a motion.
I never asked. I
However
just
you
started
wanna do
talking. So
It's implied. I'm not real comfortable with this.
I agree. I mean, I do think people can redeem themselves, and I hope that he has, and I hope he does. But this may not be the industry for him. I mean, there's rules set up, and it clearly, violates those of his background. I hope that he has changed, but I don't feel comfortable approving him.
I tend to make decisions of would I let this person into my mother's house, and that's a
Right.
no for me.
Then we can put it in the form of a motion and go forward.
Okay. I just wanted to make sure others had their chance to discuss it. I make a motion we deny this application.
Second.
What's your basis?
A basis on reoccurring.
No, we have to. We have
Oh, we
to
have to do
quote a
that.
statute. We'll look.
Okay,
we'll let Ashley
low
look it
moral
up.
character. How's that read?
All right, you want to put it on the poem? Okay.
She agrees with it, so we'll go with it.
Do we still have to cite the statute number, or?
Yeah,
What
they'll
we do.
have it for us
That's
here
what
in a
they do.
second. We'll usually put it in the motion too, so that.
Well, Ken knew all these numbers and stuff, and Ken would rattle them off when he made a motion.
62 Tennessee Code annotated 62-32-312, subpart E.
I have to add that to my motion. Then I would like to add the 62-32-312 E2.
And Scott, you seconded.
Yes. A second.
We have a motion by Mr. Cockburn and a second by Mr. Cockcroft to deny this application based on 6232-320E2. All in favor, voice by saying aye.
Aye.
All opposed? Application's denied.
All right, we'll move on to Exhibit B. This individual is also making an application to be a registered employee. I have a 2013 failure to appear, which is guilty, 2015 marijuana possession. He gave you his court documents and his written explanation.
Does it say in your records whether it's simple possession or?
No, it doesn't say, it just says marijuana possession -POM2. Right here. Okay, on we do have on the document that you can see, it says 5/6/15. He pled guilty, got 30 days suspended sentence, probation, excuse me. So that does make it a misdemeanor.
Have anything from the QA on this deal?
I do not believe so. We just have two of his written explanations. as you can see from his application, it's rather a large company that he works with.
They don't normally send send letters in.
Correct.
Drug screening.
I've read his responses. Can you tell from the police record, does it match what he's saying?
Yeah, as far as the one where he explains the marijuana, it does.
Actually, I believe that's one I brought it before you because it does talk about the marijuana. What is that? You're in a car and the police stop you and the driver doesn't claim the drugs and everybody in the car gets arrested.
Well, I think he's admitting some of it was
Yeah.
his. He's not. Well, half the time we get it wasn't. Nobody's takes responsibility.
Magic dust.
Heck, and in Nashville now, they don't even bother you for a certain amount. So he's pretty straightforward.
I agree.
And did he miss his court date because he forgot? If it was me, probably.
Well, and that court date was on a suspended license. That was before, right?
Right.
That was the driving.
Right. He got suspended on 2013, and then he didn't remember his court date, so they fapped him, and he didn't know that failure to appear existed.
Sometime.
There's a good chance he didn't know about the failure to appear, because if you look at his residences, although it was the same apartment complex, he changed apartments. And if they send him a certified letter, the postman is not going to change to the apartment that he moved to, no matter what. He may have never gotten the information. Speculation only.
Make a motion to approve the application.
Second.
Okay, we have a motion by Mr. Cockcroft and a second by Mr. Cockburn to approve this employee registration application B on iPad. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, thank you. Now we're going to go to Exhibit C. What I had down for this one was in 2009, it was shoplifting guilty. We have a written explanation, and we do have a letter from the company. Renault on the application, it does say a 12/2/2008 driver without a license in possession. That is not one of the deniable offenses.
That doesn't mean it doesn't really have any bearing, but that doesn't mean she didn't have a license. She just didn't have it with her, right?
I believe so. She didn't have it in possession.
Say, not that it matters.
Letter from the company really isn't a recommendation. It's only a verification of what?
Yeah,
Oh, yeah.
that's, sometimes we get letters and sometimes we don't.
Make a motion in light of the older information that we have here that we approve Ms. Tate for employee registration.
I have a motion by Mr. Harvey to approve Exhibit C. Do we have a second?
Second.
And a second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Thank you. And then, Scott, so, the board has granted me the approval to approve a file that's 10 years old or older. This was right on that borderline, but this would have been one that I would have approved simply because of time frame, and it's the only thing that is on the record. The woman did make very clear explanation of what it was, owned up to it, and then, of course, we did have the...
Yes, but I figured you.
Was I looking at you? Or
I'm looking at, you're looking at Glenn and calling him Scott.
We look so much alike.
Oh, that's right.
Yeah, that's
I looked over at you to see if you were, because I figured
I was
she was
watching
talking to you. Because I was going to say the same thing.
Forgive me, I'm
Yeah,
sorry.
that's all right.
But she can
No, I didn't-
administratively approve.
I don't have a problem with it anyway.
All right, the next one is D. Gentlemen, here I have a chargeback in 13. He was guilty of 50 grams of marijuana. And
Hey, hold on. What about the woman we were just talking about?
approved her. Didn't you vote? Didn't you vote?
Yeah.
Yeah, we voted.
We voted.
You
And
called
then-
it.
Okay, it's
Yeah.
not just me.
Oh, you're talking about the Tate lady from,
Yeah, we approved her.
because she's talking about somebody and it was on the 10-year line, and then all of a sudden we moved
the same
on.
No, I
one?
was just making a statement for
She
Glenn
was just
to know.
making a statement to let me know that she.
Thank you,
if it's
because I
older than
thought,
10
wait a
years.
minute, we're supposed to be on D here, and it's a man, but it's a woman, but it's a man.
These are interesting meetings, Glenn.
There's a footnote for the last one.
Okay, so this one here is Exhibit D. All right.
Started saying,
I did. Thank you. I said pled guilty in 13 of 50 grams of marijuana and 5 grams of hashish. Hashish, how you pronounce
Hashish.
that? Hashish.
I'm not a drug guy, so is that a lot or a little? I don't.
How much?
5 grams is not very much. It's a
Okay.
very small amount.
But 50 is.
50 might be a little bit more than just a small amount.
Yeah, I think.
Well, I don't know, but the small amount of the
Hash is so much more powerful.
well.
yeah.
Whatever, less than 50, less than 5.
I mean, so I've heard.
These are actually kind of hard to read. This is in New Jersey. Oh, let's see if this is the one that have the letter from the company. Actually, it just says they submitted the application, basically what they're saying there. You do have a letter from the individual explaining the circumstances. He just left some residue in his pocket, from what I could understand. Less than 50 grams. Then you have the sheet from New Jersey that explains their code. So. Code for a plea is 9, he said, and it says no plea. But he was found guilty.
Just for a little background, my friend Google, an average hash joint is 0.5 grams.
So 5 grams itself would be a lot.
A lot.
Okay.
You're welcome. Google's my friend. And I looked up 50 grams of marijuana. That's 6.25 ounces. That's
Is
6
it?
ounces? A gallon
I don't-
Ziploc bag is an ounce and a half.
Oh, okay. You
I
know
was a
quite
cop,
a bit
okay?
about. I was getting ready to say, Glenn.
I know all this
just
other stuff.
Light, I guess.
It's very, it
There you go.
is very light.
Oh, okay.
But usually an ounce, if you have some wet stuff, ounce and a half, is about a gallon Ziploc bag.
What?
A gallon Ziploc bag
Is how much now?
is
Would you
an
say
ounce,
before
ounce
the-
and a half.
Oh.
It says that, let me see, all amount was left in my travel bag mixed with my clothes. That
That was the other time, was it not? That was not the larger amount is in the car. 2011 is the larger amount when he was with friends in a car. 13 was when he was stopped on the way home from work. Had a smaller amount.
That was the hash?
No, I don't. No, I think the marijuana and hash was the 2011.
Okay.
It's still troubling. But I just to clarify when they were, because I was having a hard time following it myself from his which was which.
Closer, he'd be somebody I'd want to come in and talk to, but
Yes, it is a monitoring company.
We're not supposed to necessarily consider what their position is, because they could be a central station operator one day and they could be an installer the next. But I think we've let that.
Does the state, I mean, this is always an option, does the state of Tennessee allow electronic attendance?
Yes. I don't believe we've ever had someone by telephone.
Or telephone, video chat?
Oh, yes, if you ask me if that's an option, yes.
We've done that for a hearing, and we talked about doing that for something at the last meeting, the DIY. I asked if that was possible, and that I don't think we've ever had anyone that was an applicant do that.
I'm aware of.
I personally, without some type of positive reinforcement on this guy from a QA or something, I'm not real comfortable with him.
Back and ask him to give us letters of recommendation, and then include one from the company?
Minimum, yes. I think so.
Out of our bounds to request a copy of a drug test?
We've done something like that in the past where we've
had quarterly.
When you approve them, then we put them on that. Yes, so we do the drug test. We do drug. Ask for it, but that's usually when after we've already approved someone, they keep them honest.
Since I've been here, we did actually have one person that we approved that way, and they failed.
Yeah, they actually
later.
failed it. Yeah. Mm-hmm.
We've had others that did not happen on, but
Right, but we've done a few drugs.
Does she hang out with the wrong people? That's not for us to judge, but is there a possibility that there may be something there that would affect it, the approval? I mean, if we're allowed to ask for a drug test, I don't think that's... Now, a larger company, they probably already do it.
Right. Now, so this is where my question. We're going to approve the application based on drug screenings, or are you saying you want to have a drug test, the results before we do?
in the past, I think typically we've only done that when we saw them in person, because partially the qualifying agent has to also agree to do that.
Right, but sometimes in larger, you mean...
They might do it. They might have drug testing anyway. Yes.
Yeah, they probably...
Okay, so are you saying, for instance, you want me to contact the company, find out if they do mandatory drug screenings and get her last drug test? Can I do that legally?
You can ask for whatever you want. It's the question.
They don't have to do it.
If they decide to say no, and you haven't issued a decision on the from asking for the drug screen. And I think that's why we've always conditioned it on the approval.
Sorry. Legally, can you request a copy of drug screening pending authorization?
Again, yes, you can ask for that. Mm-hmm.
In the past, it was scheduled, or it was required. Because most companies are going to have a random drug test. Maybe they drug test when the person was hired, and then maybe they pull a particular person to drug test randomly. Whereas this particular one, what we've done in the past, I think, has been a specific every 30 days, 90 days. I don't know what it was, but it had a specific. It wasn't a random thing. And it was specific that they had to report to us if it was a positive finding or something, or do they have to report either
You
way?
have to report either way.
Okay.
I guess, Mr. Cockburn, if I can ask you, if you ask for those results and they come back that it's a clean drug screen, at that point, would you, I guess, be more application?
Yes, because from what I've read from her comments, and of course, without being directly talking to her,
I'm not
it
sure
seems
it's a
that
her
she
or
was in the wrong
he or
place at
her.
the wrong time with the wrong friends. So, is she someone who uses it or not? If she comes back clean, I don't have a problem with that. Because we all have situations where we make bad decisions. Or at least we did when we were young.
Again, it would be a conditional approval. It will be approval conditioned upon a clean. Is that what the suggestion is? The results of a clean drug screen, or is it you want testing for the first renewal cycle or whatever it is?
Personally, I'm more inclined to just deny the application, and if they want to come up, they have the right to appeal that, or they can request a teleconference or whatever. That's my personal inclination. Just, I think we should be clear. It doesn't matter, but it is a he, I think. I don't want someone to see this later and say we're talking about the wrong person. Just make sure we're talking about the right person. We could have referred to him as the applicant, but
Exhibit
but we
D.
are talking about the same person.
Yes. Sorry.
I make a motion to deny the application.
Second.
We have a motion by Mr. Cockcroft and a second by Mr. Cockburn to deny this employee registration application. All in favor, voice by saying aye.
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 All opposed? And that would be file D for the record.
I believe we can go to Exhibit E. This one also was a little hard to follow. I had it down as a 1998 receiving stolen property in second and third degree, but did not get sentenced until 2001 with 3 years probation.
I think probably what she did was her summons date versus her conviction date. On this next one, is there anything that stands out on that New Jersey report? Because it's really hard to read.
Okay, on the actual criminal record itself, that's what I was just talking about. It said arrest date 7/29/1998, count 1 receiving stolen property, knowingly received stolen property, indictment accusation, disposition guilty, felony conviction. Then it says the second one is receiving stolen property, no felony conviction. The third one, that was guilty. The third one, guilty, degree, third, receiving stolen property. And according to the record, she only had, or it could be he, 2 felony convictions, even though it shows 3. see, this is a little hard to read here too. Third and fourth degree. It'd be real hard to read that state of New Jersey. If you'd like to look at the original, I have the original. Oh.
I'd like to make a motion to grant, and I can't read the name, Exhibit E, employee registration.
Okay, we have a motion by Mr. Harvey to grant Exhibit E employee registration. Do we have a second?
It is a
Severity of the crimes.
long time ago. I guess I was curious if there's why she was convicted. If there, was there not proof of where it was from, and that her
Yeah, the details are lacking.
Yeah, there's some inconsistencies. Previously being a police officer, she took her stuff to the pawn shop, and that night they came and arrested her. Other than visual ID, you have to go get a warrant for something like that, and et cetera. Usually a detective's involved, and several hours later, knocking on the door to arrest her. I can't dispute what she says. It just sounds fishy.
I'll second the motion to approve.
Okay, we have a motion by Mr. Harvey, a second by Mr. Cockcroft to approve application, is it E we're on now? Application E, or file E. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
I'm sorry.
One way or the other?
Or abstain.
Abstain.
Motion carries 3-0.
That's 3 in favor and 1 to abstain. I do. Pay attention.
Sorry. I was still reading.
Okay, if it's all right, we'll move to Exhibit F. Hard to follow also, I had a 2009 fraudulent use of credit card under $500, probation 1129, and there was 3 counts, 500, and it looked like it might actually have been 8 counts. Get it together. if you look at the court document, it looks like it's in guilty 7/3/2009 of fraudulent use of credit card under 500. The first one I've got is counts 1 and 3, 1129, and then the next one says counts 2 and 3, 1129. The one left under 5, I'm trying to see, is different. The indictment date is different, and it's for counts 1 and 2 with 1129. So
What it is, some of them's theft and some of them are fraudulent use of a credit card, so they're different criminal charges.
Right, the offense
they're
date is
still
the
the
same.
same. I mean, it's still against. Okay, it got a little confusing to me.
I have a copy of his TBI report. Does that come back different than what he provides from the Wilson County?
The first one was 4/17/2010 fraud forged prescription. That's the one that got dismissed, if I'm not. Then the other is on 10/15/2009 theft forgery for credit card. 1, 2, 3, 4, 5, 6, 7, 8. It looked like there was 8 counts. Documents just show 1, 2, and 3.
There's a good chance that they may have combined them.
Have a response in here anywhere? I see the one small page.
Yes, you had just a small where he mentioned 2 things, if I'm not mistaken. 2007, pled guilty to a simple possession, unable to get court docs. And then the other one is I pled guilty to 3 misdemeanor theft charges in 2010 for purchases made with the credit card that wasn't his.
Now, you counted 8 on the TBI report. Does it say that he pled guilty?
Doesn't say anything on other than what the charges are.
Qualifying agent either.
No, so you got everything that was sent to me. It is a local company, a Tennessee company.
I think on this one, I'd like him to appear. I was just seeing if anybody had any other thoughts. I make a motion that we request him to appear before the board.
Second.
Okay, we have a motion by Mr. Cockburn and a second by Mr. Cockcroft to ask applicant F to appear before the board. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Yes, we're going to move to Exhibit G, please. At a 2015 manufacturer under deliver or delivered to with possession with need to move down on the record that you've got there. That first one was dismissed, vehicular insurance or lack of. Second one for the controlled substance manufacturer delivery, that one was also dismissed. So you're looking, I believe, at count 3 as guilty of controlled substance manufacture or deliver. I'll go ahead and explain for Scott's also. I mean Glenn, for Glenn also. It does show some other charges there, for instance, the fugitive from justice, but we do not take a look at that. Whenever we have a hit, the TBI, the FBI will pull it and they'll go ahead and run it for us. If the individual wanted, I would already know about that. So that's not to be.
Excuse me.
On page 13 of 16, there's a list of, there's entries. Not sure what they are.
What, this list?
Yeah.
If you look at the bottom of page 12, I think that's part of the address/identity history information.
So we have no explanation from him, correct?
No, I don't have one.
On page 11 of 16, his NCIC report. Oh, NCIC may have changed the last time I've looked at them, but isn't that like an extensive history in the state of Iowa and before it gets into the addresses?
We don't have any of that on his TBI or FBI record. I'm sure if he's been convicted of this, I would have a record. It'd be on the record, but that's not on his TBI and FBI. The shows that he has one felony.
Is NCIC admissible? I mean, that's the National Crime Information Center.
Yes, that's over there, and this I already got both of them. And no, sir, I don't have this information here on the FBI report. Why, I don't know. Okay, so it looks like we've got information that he's provided to us that is not on the TBI or the FBI record that we need to probably find out why. Yeah. Or I can contact them. This is a Utah company. I can contact them or the individual and ask him for his written explanation.
I'd like to see him.
What's going on?
I'd like to see him before us. I mean, there's a lot of conflicting information.
Okay. The company, I misspoke. The company is Utah, but his address is actually Memphis. So if you want me to ask him to make an appearance like the other gentleman, I can.
I make a motion.
We just denied.
Well, the only problem with that is all that could have been expunged, or it could have been after that, or it could have been the version that got taken off, or there's a problem with this FBI record.
I think we deny it, and if it's all wrong, then it's up to him.
It's up to him to clean it up.
Yeah, I mean, if this is that important to him, he should have gotten it straight to begin with. You gonna make a motion, Keith?
Yes, I would make a motion that we deny Mr. Watson his employee registration.
Second.
232, 312E2. And this will be seconded by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
All opposed? The application is denied for F. Or, excuse me, G.
All right, the next one's not on your iPads. That's the one that I handed out to you.
Are you still getting a lot of paper apps? Because aren't all of these on here paper? Yeah.
Thank you for noticing that. Most of them's all the same company. We will be talking to these people.
Okay.
Don't make her
I am not, unfortunately, I'm not in a position where I have to say at this particular time that I have to return your check. The state, no matter who it's made payable to, it doesn't get returned. as you know, we're moving towards everything to being electronic, so we are strongly encouraging, but I still have a few companies that are resistant to that. But some of these are quite big companies, and I contact usually the corporate office instead of the qualifying agent. I seem to get better response that way. Let the people higher up know that we're not getting it. And a lot of them are also other offices. I might have three. It's a big company. I got 3 offices that do it electronic, 1 office that doesn't. That's why we have offered our service to them to try to help them. I'm going to try to help you here with his sheet. He said, I pled guilty to a 1995 forgery. I pled guilty and got 1 year of probation to possession of crack cocaine. I pled guilty to possession of CDS marijuana. Traffic, I didn't worry with that one. I pled guilty to prowling in public places. 2002. 2005, it was dismissed. 2005, I pled guilty to possession of drug paraphernalia. 2006, I pled guilty to prowling in public places. 2006, I pled guilty to prowling in public places. I pled guilty to a DUI in 2012. I pled guilty to wandering and prowling in 2016 to obtain or sell CDS, which would be marijuana. And on 2016, I pled guilty to possession of drug paraphernalia. Documents there.
Just as a point, the 2016, according to the report, was crack. Having his control and possession a clear orange heat-sealed baggie containing a white rock substance believed to be crack cocaine.
Make a motion, we deny Mr. Murray his employee registration.
I second it.
We have a motion by Mr. Harvey and a second by Mr. Coburn to deny application H, employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? Application is denied.
All right, thank you, and that does conclude the criminal history review. We could go right on to education if you want to, or we'll take a break now. Thank you.
And you can.
The next one is the Jade Learning, and is it just they've had a name change?
Yes, I wanted you to see that. I wanted to get it into the record. Jade Learning, JADELEARNING. We're writing to inform you as of March the 30th, 2018, Jade Learning, LLC, has been purchased by TPC Midco Corporation, LLC. We are no longer owned by Testwell, TESTWELL Holdings, LLC. Now, Jade Learning, we just accept that they're automatic, so I just bringing it to you to tell you, A, they do have a name change, B, are we still going to honor that as they send them in, they are automatically approved?
I would think so if it's just a name change.
They just have a holdings change, right?
I didn't know they were automatically approved. Was that something? So we don't
Been
even
a long-
look at those?
They've been a long time.
What qualified them for that?
Well, that was a long time ago whenever the board voted them in for that. Just like the Electronic Security Associations, there's several of them that we
Well, as long as
automatically
your
accept.
courses, I think as long as the course or the classification doesn't change, it's been accepted. But if they make a change to the classification from training to CEU or whatever, then the board has to approve it.
All right, did we decide that that was okay? You need me to present them again, or
I
Vote
wouldn't
on
think
that.
it's
so.
okay to keep it on the course list is what I'm asking.
You want a motion to make it all
Please.
good? Okay, motion.
Second.
I
No.
make,
You have to make the motion.
I make
first
a
before you
motion that-
second
Oh, I
it.
thought you made the motion. I'm
No, I
sorry.
said we need a motion.
that we accept the new name for Jade Learning as the TPC Midco Corp. And continue accepting the courses that they submit.
And now we need a second.
Second.
Okay, we have a motion and a second to approve or to acknowledge the name change from Jade Learning Centers Holding Company from, I think you read it out, from TC to MidCorp. Is that it? All in favor, voice by saying aye.
Aye.
Aye. All opposed?
Then we've broken this down, this is continuing education. Okay, so you should have already got some of this correspondence from ESA who wanted to continue in education. And it comes down into Innovonics, Security Net as well. Several pages of that. Does anybody on the course list?
I had
They
no
want-
negative discussion.
I beg your pardon?
I had no negative discussion. I thought
Okay.
all
Okay.
those that was
Okay.
asked for an hour and a half of continuing ed was fine. And I did read through every single one of them.
Yeah, I appreciate that. You're the expert. Thank you. I'm sorry, I did, is there any other discussion on this? The other board members?
Are the majority, these are all CEUs, correct?
These are all CEUs for ESA. Like I said, CenturyNet. Back. We have approved Seymour, CMOOR Group. Expiration. So they have resubmitted their courses for us. I think it's every 4 years. They have to renew their courses, and that's what was attached on the back. But yes, ma'am, it is continuing education. Oh, I believe Scott said yes. I mean, Keith, I'm sorry. Scott, did you review them?
I looked through. I mean, it's one big document of all of them, right? Or-
Yes, sir, just a one piece. Yes, sir, for that section. But we're only doing the ESA down to begin with, the reapproval of the 56 online continuing education courses for Seymour Group.
Including the CenturyNet.
Yes.
Okay. CenturyNet ones, I mean, it looked like there was a lot of cut and paste and as far as the description and stuff, but it still did look like it met the hours. Some of it is a lot of discussion, is what it says in the class.
Okay, are we going to, how do y'all want to vote on this? Do you want to vote on ESA and I've got one Innovonics, CenturyNet?
Okay, we can do it something very simple. I sent it
Or-
all out to everybody. not Vivian, everybody take a look at the courses. Was there any discussion on any of the information that we sent out, or can we go ahead and do a blanket and vote for the continuing education that was sent out? That might be a whole lot easier.
Nothing that stood out with me.
That's fine with me.
Do we need to make a motion to do it as a blanket?
Yes, sir.
Approve all courses presented for continuing
presented.
education.
Well, I make a motion that we accept all courses as presented for continuing education.
Second.
Okay, we have a motion by Mr. Cockburn and a second by Mr. Cockcroft to approve all the courses presented by the different companies for continuing education. All in favor, voice by saying aye.
Aye.
All opposed? The motion passes.
All right, so I think we got a question, well, probably two. Do we need to, Vivian, do we need to start sending them you? Since you're the public member, I did not send them to Vivian to review the courses. Do you like it that way? I can just send them all out to you. You've looked at all of them, then we just come back in, and the ones that we need to discuss is the ones we'll discuss. The other ones can be approved.
Yeah, because in the past, what you've run into is if you send the courses to one person and they don't have the opportunity to review them, then the other board members are scrambling during the meeting to try to determine are they okay or not. And you've got a 4-to-1 shot versus a 1-to-1 shot that somebody's going to say, yeah, I've looked at them and I agree. And then we can vote on them without having to read up on them real quickly.
Okay, I think what we'll do for now, we'll just get a list of them, what the name of the course, and then I'll just do it like that. Everybody get theirs. We'll say, is there any discussion, or are we going to approve this list? Just read the list out, and that'd be.
I mean, it's a lot to look at. This was like 400 and something. What is it?
This
pages.
was odd because
Yeah.
the Seymour group happened to be renewed, and.
Because in the past, if I was sent just some, I knew I needed to look at them, and I looked at them good. I looked at this, but I did not look as thoroughly since it was so much. So it's kind of harder. If we do send it to all, we may all sort of look at it.
I agree with that.
Okay, so do you want me to send it all out and
looking at a
send
lot
it?
of this, aren't we?
We just send it all out. Then I'll say, well, Keith, would you take the first 5 pages? Scott, you take. Glenn, you take.
Yeah.
But you still need to be aware of what each person has, so we can make an honest
That would probably be better.
recommendation. That'd be okay?
Yeah, that's fine, because, you
Okay.
may see something that I don't.
It's good to see all of it, but it still would be nice if we focused on a certain part or something.
Okay, we could do
I
that.
think in general, the board has always been accepting of what the companies have asked for on CEUs. I think where controversy comes up is when they want to give too many training hour credits, or they want it in different classifications that y'all don't think they fit
Official out.
into.
Official.
Yeah.
Well, there have been a few with the continuing education where they've asked for 4 hours and you reduced it to 2 hours, something like that. That's why we need to review them. But I can do that, so I think what we'll do, we'll make it a policy that we'll send all the courses out to you, but we're asked each person to look at a section. But all of you be prepared in case that maybe the individual might not be here.
And if somebody doesn't have an opportunity to review their section, let the rest, let others know so that somebody else can kind of pick up the gap then. That take care of that part of
yeah,
it?
that took care because we had the vote. That, yes, ma'am, it sure did. That was the continuing education course approval. I didn't have any unfinished business, but under new business, you do have had to move a meeting.
I think we changed it from,
We changed it now to June. It was the 21st of June. Now it's the 28th of June. Okay, that's all I had under new business, Madam Chair. I just want to make sure everybody got the
Okay. Anything else? Our meeting is adjourned. Thank you for coming.
Good thing we didn't have that here.